Welcome to Cona's Corner. I'm Jennifer Cona. In this segment, we answer questions that you write in on anything related to elder law and trust and estates. Write in to elder@conalaw.com and we will help answer your questions. So today's question is, my 3 children don't get along. Should I appoint my friend, an attorney, as my executor? So this is an interesting situation. People really do struggle with who they should appoint as their executor. And they will debate amongst their children who's good with responsibilities, who's organized, who's good with finances, things of that sort. But the truth of the matter really is that your executor is ultimately going to hire an attorney to do the work of admitting the will to probate and all the work that follows. There is a lot to the probate process. There is a court petition, there's a court appearance, there's filing accountings, inventory of assets, collecting all the assets, paying debts, negotiating with creditors, filing tax returns, all kinds of things like that the typical person out there has no experience with and wouldn't. So they can't be expected to handle that. So the executor's job really is to work hand in hand with an attorney who will do all of that with them. So you don't really need to ferret out your child who has experience with those things, because they're not going to. So that's the first thing to think about. And when you sit down with your attorney, you'll discuss those kinds of things. So we had a case similar to this where the person did appoint a friend who happened to be an attorney as the executor, and that seemed like a very sound decision for her. And you know, of course, we honor our clients' wishes after we, discuss them at length. And what happened in that case is that the attorney friend was an older gentleman, and at the time that our client passed away, and he was retiring from his practice. So administering the will and the estate was really kind of on the bottom of his priority list at the time she passed. So the will was admitted to probate, but he really didn't want to do many of his executive responsibilities. He was not prioritizing collecting the assets. He wasn't prioritizing dealing with the creditors, handling the taxes, doing all of the things an executor needs to do. And the estate dragged on. The estate dragged on for about 6 years, and the heirs didn't receive their money. If it had been a family member, they would have run with it, hired an attorney whose job it would have been to get this over the finish line. And they would have done so, and it would have been wrapped up probably within a year or close to that. And just so all of you know, an estate must be held open in New York for 7 months. That's a statutory period of time, because creditors have to have that amount of time to come in with any claims against the estate. But after 7 months, an estate, if all is well, can be wrapped up after that period of time. So a typical estate might be open for 8 months to a year. So you want to give a lot of thought to who you're appointing as your executor, and any fiduciary for that matter. It's such an important job, and it's not necessarily what you really think it is, and we need to dig a little deep in those conversations. And that's what we do here at Cona Elder Law. We talk about it and what it really means, and you should be doing that with your attorney. So thanks for tuning in. Write in with any questions you have to elder@conalaw.com, and please share, like, and subscribe, and we'll see you next time on Cona's Corner.